Selling a home with a deceased on title? Here's how to tackle it in 2 easy steps. Okay, so you're about to go into a listing presentation, Form 6 in hand. The plan is to sign up the vendor and get the property listed. But one of the parties on the title search has passed away, and you don't want to mess up the Form 6 because an invalid Form 6 would not be a great result. Here's my top tips to make sure the process goes as smoothly as possible. The first thing you need to do is work out whether the tenancy or ownership is joint tenants or tenants in common. So how do you work this out? The tenancy will be noted on the title search right next to the parties' names. So you now know what the tenancy type is, but what's the difference? Joint tenants versus tenants in common. When 2 or more people own a property together in Queensland, they have the option to choose between the 2 types of ownership, joint tenancy and tenancy in common. Now, this occurs during the conveyance when they're buying the property. In joint tenancy, all owners, noting there can be more than 2, own an equal share of the property, and if one owner dies, their share goes to the surviving owner or owners. This is known as the right of survivorship. Traditionally, you'll see husband and wife with this style of ownership, so the survivor automatically has a legal right to inherit the property. Tip: this is the easier of the 2 to change over at the titles office, a much easier and faster process to finalise. On the other hand, for tenants in common, each owner has a specific share of the property, and if one owner dies, their share goes to their beneficiaries. People they leave their property to in a will or legal document. You usually see this style of ownership with siblings, friends, business partners, and partnerships that have children from previous marriages, or those who wish to hold the property in unequal shares. With the tenants in common option, the deceased wishes for their share of the property to be dispersed as per their instructions in their will, not automatically transferred to the other owners on title. Now, note, this process generally takes longer to finalise at the titles office, as it may require probate, which can take months to come through. How to correctly prepare your Form 6 and contract with a deceased. If joint tenants, the survivor or survivors have a legal right to the deceased's share of the property. So on both the Form 6 and the contract, you'd list only the survivor or survivors on title as your client and as the seller. The will terms, beneficiaries and executors do not come into play here. There is then a process required to perform a request to record death, which means lodging the death certificate and a form at Titles Queensland to administratively remove the deceased from the title. This can be actioned within a traditional 30-day settlement, as they have the death certificate and usually the conveyancer acting for the seller can assist with this process. It's certainly a process that we look after on behalf of our clients. Please note, you should also include a special condition that our office can provide to ensure the vendor is protected prior to signing. If tenants in common, or if the only person noted on title has passed, replace the deceased person on the Form 6 and the contract with the following phrase: name of executor as personal representative of the estate of name of deceased. For example, George Souris as personal representative of the estate of Bob Souris, who turns out is deceased. If you are unsure who the executor is, please ask the vendor. If they are unsure, there should be estate lawyers involved who can help. The next step is a transmission application, which is the legal process that appoints a legal representative on behalf of the deceased. Usually, this is taken care of by the estate lawyers. This process must be completed before the matter can settle, as it will remove the deceased from the title and replace the deceased with the personal representative who will have the legal right to sell the property. The above process requires a special condition to be inserted into the contract, which we can provide, and is extremely unlikely to be fulfilled in a traditional 30-day settlement situation. This calls for a longer settlement to ensure the vendor can get the transmission application sorted in time. Please feel free to contact our office for any guidance here. Now, a couple of extra tips before we wrap up. Remember, dead people cannot sign, so don't put them on the Form 6 or the contract. Also, a power of attorney or POA ceases to be valid as soon as the principal, who is the person giving the power of attorney, is deceased. It is legally useless once the principal has passed, so please don't rely on a power of attorney when dealing with deceased. Wrapping up, when dealing with how property is held and the process of dealing with a deceased owner, it is a trickier area of property law in Queensland. As agents, you're not allowed to give legal advice, so it's in your best interests to handball the liability over to the lawyers. We are happy to help and we'd love to take care of your clients. If you need anything at all, please do get in touch and see how the Empire Legal team can make the experience for your clients seamless and in turn make your life easier. Thanks guys, chat soon.